Smith has enumerated canons of taxation which are accepted universally. So here options are equality and certainty, equality, convenience and economy, equality and economy, equality, certainty, convenience and economy. These four these are four canons of taxation which was given by Adam Smith in which is accepted universally. Okay, let's move to next question. For the first time in India, income tax laws was introduced by Sir James Wilson in the year, it was in year 1860 after the revolt of 1857 to meet the losses. So next move to next question, question number 3. Under which section of Income Tax Act income of other persons included in SSC's total income? 56 to 58, 66 to 65, 45 to 54 or all of the above? Here the answer is answer B, 66 to 65. 56 to 58 is about income from other sources. 45 to 54 is about capital gains. So here the answer is 66 to 65 of Income Tax Act. Question number 4. According to Motor Vehicles Act 1988, which factors determine the jurisdiction of licensing authority in applying for a driving license? So first option is the place where the applicant has family ancestral property. No. The place where the applicant has held a bank account for more than a year. No. The place where the applicant votes in local body elections. No. The place where applicant ordinarily resides or carries on business. It is given under section 9 of MV Act. Now next question is question number 5. A period of 12 months commencing on first day of April of every year is known as, option A is assessment year, option B is leap year, C is previous year, D is none. So everyone knows about leap year, so it can't be correct. Previous year, no. So here the answer is assessment year. It is given under section 2 subclause 9 of IT Act. Previous year is the financial year preceding the assessment year. So here the answer is A, assessment year. Now next question, question number 6. Specific relief. Here it is to be filled. Specific relief dash where the agreement is made with the minor. So specific relief can get where the agreement is made with the minor? No. Specific relief cannot be given where the agreement is made with minor? Yes, it is correct. So can release? No. Implemented with law? No. So an agreement with minor is void ab initio, and it was held in Mohiri Bibi Mohiri Bibi versus Dharmodas Ghosh case. So, next question, question number 7. Read the given statements and choose the correct option. A dispute arises A dispute arises between two companies regarding the enforcement of their arbitration clause. Examine the following statements. Statement 1 is an arbitration agreement must be in writing and it can be contained in a contract, an exchange of letters, telex, telegram, or electronic communication. And second statement, statement 2 is an arbitration agreement may be implied solely from the conduct of the parties without any written record. Here it is very clear that statement 1 is correct and statement 2 is not correct. So statement 1 is true. Section 7 of Arbitration and Conciliation Act Conciliation Act 1996 requires the agreement to be in writing. So it cannot be implied solely from the conduct of the parties. It should be written only. Next question, question number 8. A person entitled to the possession of specific immovable property may sue in the manner provided by. Here the options are Code of Civil Procedure, Indian Registration Act, Indian Contract Act, Transfer of Property Act. Here the answer would be Code of Civil Procedure. Code of Civil Procedure, CPC. Section 5 of Specific Relief Act Specific Relief Act provides that recovery of specific immovable property should be in the manner provided in CPC. So here answer would be A, Code of Civil Procedure. Next question, question number 9. Section 39 of Specific Relief Act deals with. Here the options are registration of instrument, no. Cancellation of instruments, no. Correctness of instruments, no. So here the answer would be option number D, none of the above. Section 39 of Specific Relief Act deals with mandatory injunction. Now question number 10. What kind of property is transferable? Pension, public office, right to re-entry, any kind of property if not prohibited by law. So can we transfer property? No. Can we transfer public office? No. Can we transfer our right to re-entry? No. So here the answer would be option number D, any kind of property if not prohibited by law. It is given under section 6 of Transfer of Property Act, TPA. Moving to next question, question number 11. According to Payment of Gratuity Act 1972, under what circumstances is the completion of 5 years of continuous service not mandatory for payment of gratuity to an employee by his employer? First option is voluntary resignation from the post of the employee. Dismissal. Option number B is dismissal of employee due to misconduct at work. Third is death or disablement of the employee due to accident or disease. And D is transfer of the employee to another department within the same organization. Here the answer is C. Here proviso of section 4 subclause 1 provides it waives the 5-year condition where service is where service ends due to death or disablement. So here answer would be C. Death or disablement of employee due to accident or disease. Now moving to next question, question number 12. The parties which cannot be compelled to perform specific performance of contract are provided under which section of Specific Relief Act? Here the options are 27, 28, 29 and 30. यहाँ ऑप्शंस में कुछ गलती है, तो here the answer is section 14 to section 16 of Specific Relief Act provides for the provision that parties cannot be compelled to perform specific performance. Next question, question number 13. Who among the following cannot transfer an immovable property? Hindu widow, yes, she can transfer. Who among the following cannot transfer the immovable property? So Hindu widow can transfer. Muslim widow, yes, she can also transfer. Natural guardian of a minor, let's consider it later. Karta or manager of a joint Hindu family, yes, he can also transfer. So here the natural answer is option number C, natural guardian of a minor. It is given under section 8 of Hindu Minority and Guardianship Act, that a natural guardian cannot transfer the immovable property of the minor without permission of the court. So their answer is C. Moving to next question, question number 14. In the absence of an agreement between the parties, the arbitration proceedings are said to have commenced under section 21 of the Arbitration and Conciliation Act 1996. Option A is on the date of appointment of arbitrator. Option B is on the date of arbitration agreement is signed. Option C is on the date the request for reference is received by the respondent. And option D is on the date the arbitral tribunal issues notice. So here the answer is option number C, on the date the request for reference is received by the respondent, and it is given under section 21 of the Arbitration and Conciliation Act. Next question, question number 15. Section 14A inserted Section 14A inserted by the Specific Relief Amendment Act 2018 relates to power of courts to engage experts, establishment of special court, expeditious disposal of the case, or the specific performance with regard to contracts. So, establishment of special court is given under section 20B. Expeditious disposal of the case is given under 20C, and the section 14A relates to power of the courts to engage experts. So, answer is option number A, power of courts to engage experts. Now moving to next question, question number 16. Delivery of goods by one person to another for a purpose to be returned, disposed of per direction when the purpose is accomplished is termed as. So this process is termed as, let's understand these four terms first. So agency. What is agency? Agency concerns acting on another's behalf. That is, someone appoints an agent on his behalf. It is called agency. Bailment. So bailment is delivery of goods by one person to another for some purpose upon a contract. Here the answer is B, of course, bailment. But what is guarantee? Guarantee is a person guarantee is performance of a third party's obligation. So here the answer is B, bailment. Here contingency is nothing relevant to this act. So uh, option B is correct, bailment. Question number 17. According to Motor Vehicles Act 1988, what is the fixed amount of compensation payable in the event of death caused by motor vehicle accident under no fault liability? 25,000 rupees, 50,000 rupees, 1 lakh rupees, or 75,000 rupees? Here the answer is 50,000 rupees. It is under old section 140 of old act. In case of death, it was 50,000 rupees, and in case of disablement, it was 25,000 rupees. Now, moving to next question, question number 18. Under the Land Acquisition Act, the expression land includes benefits to arise out of land. Yes. Things attached to the earth. Yes. Things permanently fastened to anything attached to the earth. Yes. All the above. All the above options are correct. Question number 19. Temporary occupation of land or arable land. Procedure when difference as to compensation exists is provided under which section of the Act? Section 32 of the Land Acquisition Act, Section 30 of Land Acquisition Act, Section 35 of Land Acquisition Act, Section 31 of Land Acquisition Act. So, Section 32 deals with application of deposited money. Section 30 deals with disputes as to apportionment. Section 35 of Land Acquisition Act deals with temporary occupation of waste or arable land. So option C is correct here. And section 31 deals with payment of compensation. So option C is correct here. Now, next question 20. World Intellectual Property Organization replaced the pre-existing GATT, no, BIRPI, no, sorry. Option B is correct, BIRPI, that is United International Bureau for the Protection of Intellectual Property. So option B is correct here. Question number 21. Under section 9A of Advocates Act 1961, a legal aid committee of a bar council shall consist of not exceeding 13 but not less than 9 members. No. Not exceeding 11, not exceeding 11 but not less than 7 members. No. Not exceeding 9 but not less than 5 members. Yes. So option C is correct here. Section 9A of Advocates Act fixes the legal aid committee at not less than 9 and not more than 9 but not less than 5 members. So option C is correct here. Next, question number 22. Intellectual Property Appellate Board is established under which act? So it is first option is Copyright Act 1957, no. Patent Act 1970, no. Trademark Act 1999, yes. So option C is correct here, the Trademark Act of 1999. Question number 23. Imagine an IPL team sets up a company to sell its own range of clothes. What type of intellectual property can the team use to show that the clothes are made by them? So, first option is patent. So, patent is not for, patent is only for inventions. Something new is invented, then patents are used. So, and geographical indication. It refers to goods originated in a particular region and not a singular producer. Trademark is correct option here. It identifies the source or brand and shows who made the goods. So option C is correct here. Trademarks. Next question. Question number 24. How long do patents usually last for? Patents usually last for, it is 20 years. 20 years from the filing date. Now, next question. Question number 25. Within what period from the date of publication of declaration, if no award is made, the entire proceedings for the acquisition of land shall lapse as per the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act. So here the answer is 12 months. It is 12 months. Section 25 of Land Acquisition and Rehabilitation Act requires the award to be given within 12 months from the declaration, otherwise the proceedings lapse. Question number 26. Which section of the Advocates Act 1961 provides for the disciplinary power of the Bar Council of India? So here the clear answer is section 86. Section 35 deals with State Bar Council disciplinary power, disciplinary committee. Section 37 deals with appeal to BCI, and section 38 deals with appeal to Supreme Court. So here the clear answer is option number B, section 36. Next question. Question number 27. What is the minimum percentage of affected families that need to give their prior consent for acquiring land for private companies as per the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Settlement and Resettlement Act? It is 80% for private companies and 70% for public-private partnership. So here the answer is B, 80%. Now next question. The Supreme Court of India in R.K. Anand versus Registrar Delhi High Court 2009 held an advocate guilty of misconduct for option A is threatening judges and use of abusive language during proceedings. B, filing false affidavits and making reckless allegations against judges. No. Interfering in criminal trial by attempting to influence a witness. Correct. Circulating scandalous pamphlets against the sitting chief justice. No. So here the answer is C, interfering a criminal trial by attempting to influence a witness. This case is also called BMW case. Moving to next question, question number 29. Who has defined tort as tortious liability arising from the breach of duty primarily fixed by law? This duty is towards persons generally and its breach is redressable by an action for unliquidated damage. So, here the answer is Winfield. Winfield, because Salmon gave the pigeonhole theory. So here the answer is Winfield. Next question is question number 30. Gloucester, uh, Gloucester Grammar School case relates to which maxim? First is damnum sine injuria. Damnum sine injuria, that is damage without injury. Injuria sine damno, that is legal injury without loss. So these two are not relevant here. So here the option A is correct, damnum sine injuria. Glucosta grammar school case relates to the maxim damnum sine injuria. Now next question is question number 31. Which of the following provision of the Motor Vehicle Act 1988 relates to no fault liability? Section 140, 151, 162 or 128. So here the answer is 140. It relates to no fault liability. Section 151 relates to no fault, sorry. Section 162 relates to interim relief, and 128 concerns safety measures. Safety measures. So option A, section 140 is correct. Question number 32. Given below are two statements, one labeled as assertion and the other labeled as reason. Assertion is an employee can be deemed to be in continuous service for 1 year only if he has worked for 365 days in the preceding 12 months without any interruption. And reason is, under the Payment of Gratuity Act 1972, continuous service may also include periods of interruption due to sickness, accident, leave, layoff, strike, or lockout not caused by the employee's fault. Here, the clear answer is A is false, but R is true, because Section 2A of Payment of Gratuity Act does not require uninterrupted 365 days. So here answer would be D, A is false and R is true. Question number 33. How many consumer rights are identified under Consumer Protection Act? 2, 4, 6 or 8? Here answer is C, 6. There are 6 rights identified under Consumer Protection Acts. So first is safety, second is information, third is choice, fourth is right to be heard, fifth is redressal, and last is consumer education. So these are the 6 rights identified under Consumer Protection Act. Next question is question number 34. Which of the following body constituted under Consumer Protection Act 2019 is authorized to render advice on promotion and protection of consumer rights under the Act? Central Consumer Protection Authority. So it cannot be the answer because it is the regulator or enforcer. Not an advisory body. So here the answer is Central Consumer Protection Council. Option number B. Moving to next question, 35. In the following question, a statement is followed by two conclusions, 1 and 2. Statement is, according to the Advocates Act 1961, when the term of a state bar council expires without an election, the Bar Council of India shall constitute a special committee consisting of the ex officio member of the State Bar Council as chairman and two nominated members. The special committee has the power to discharge all functions of the State Bar Council until the new council is constituted, and elections must be held within 6 months unless the period is extended by Bar Council of India. Now see the conclusion. The special committee is empowered to handle pending disciplinary matters of the State Bar Council, and uh, the Bar Council of India may extend the 6 months period for holding the election to the State Bar Council for the recorded reasons. So both the options are correct, and here answer would be C. Both conclusion 1 and 2 follow. Question number 36. In which of the following landmark case it was held that principles of natural justice were applicable not only functions to judicial and quasi-judicial functions but also to administrative functions. So here the answer is A.K. Karaipak versus Union of India. It extended or blurred the line and extended the principle of natural justice to administrative action. So here answer is A. A.K. Karaipak versus Union of India. Ramjavaya Kapoor versus Union of State of Punjab is it relates to executive power doctrine. Next question, 37. In which of the following judgment the Supreme Court had comprehensively reconsidered SP Sampath Kumar versus Union of India case? So it is L. Chandra Kumar versus Union of India. In this case, the Supreme Court reconsidered SP Sampath case and held judicial review by High Court or Supreme Court a basic feature. So here answer is B. L. Chandra Kumar versus Union of India. Question number 38. Who among the following defined governmental power administrative law as the law relating to control of. This question seems to be incomplete. Who among the Who among the following defined administrative law as the law relating to control of governmental power? So here the answer is Wade. Option number B is correct. Ivor Jennings gave a different definition. Casey Davis focused on discretion. Gardner gave a different formulation. So answer here is Wade. Option number B. Question 39. According to the Copyright Act, What is ordinarily the maximum punishment for copyright infringement under section 63? Imprisonment up to 3 years and fine up to 12 lakh rupees. Imprisonment up to 2 years and fine up to 1 lakh rupees. Imprisonment up to 5 years and fine up to 3 lakh rupees, and imprisonment up to 7 years and fine up to 5 lakh rupees. Here the answer is A. Imprisonment up to 3 years and fine up to rupees 2 lakh rupees. It is prescribed under section 3 of Copyright Act. Moving to next question, question number 40. In which of the following case, section 66A of Information Technology Act 2000 was struck down by the Supreme Court? It is Shreya Singhal versus Union of India case. It was violative of section 19(1)(a) of the Constitution. So it was struck down. Question number 41. In which of the following case an electronic record shall not be attributed to the originator as per the Information Technology Act 2000? So, sent by originator himself, electronic record sent by originator himself? No. Electronic record sent by an authorized person? No. Shall not be attributed to the originator as per Information Technology Act. So, electronic record sent by an automated system programmed by him? No. Electronic record sent by an unauthorized person? Correct option is D. Electronic record sent by an unauthorized person. Moving to next question, question number 42. Here, general defenses in tort with list 1, match list 1 general defenses in tort with list 2 leading cases and select the correct answer using the codes given below. So, act of God is related to Nichols versus Marshland. So, it is option 3. Consent is related to Hall versus Brookland. So, it is option 4. Statutory authority is related to Vaughan versus Staff Whale Rail. So, it is option 1. And necessity is related to Last Kirk versus Gregory. Option 4. Option 2. 3, 4, 1, 2. 3, 4, 1, 2. 3, 4, 1, 2. Option C is correct here. So, moving to next question. Question number 43. What is the maximum period for which a woman shall be entitled to maternity benefit under the Maternity Benefit Act 1961? So, maximum period for which any women shall be entitled to maternity benefit under Maternity Benefit Act would be 26 weeks. It was after 2017 amendment. So, correct answer is D. Next question, question number 44. For what duration is a woman entitled to leave with wages for tubectomy operation as per the Maternity Benefit Act of 1961? So, a woman is entitled to leave with wages for tubectomy operation for a period of 2 weeks under Section 9A of Maternity Benefit Act. So, correct answer is A, 2 weeks. Question number 45. Under the Land Acquisition Act 1894, what is the minimum period that must elapse between the publication of notice and appearance of person interested in interested before the collector. So option is not less than 7 days, not less than 60 days, not less than 15 days, not less than 30 days. Answer is not less than 15 days. It is given under section 9 of Land Acquisition Act 1894. Next question. What should be the minimum number of workers originally employed in any factory for having at least one canteen in the factory as per Factories Act 1948? 100 workers, 150 workers, 200 workers or 250 workers? Here answer would be option number D, 250 workers. It is given under section 46 of Factories Act 1948. Moving towards next question. Question number 47. Who among the following is not included in the definition of a workman under as per Industrial Disputes Act 1947? A supervisor drawing monthly salary of 6,000, a supervisor drawing monthly salary of 8,000, supervisor drawing monthly salary of 10,000, and a supervisor drawing monthly salary of 12,000. So any person drawing wages exceeding 10,000 per month is excluded from the definition of workman. So answer would be D, a supervisor drawing monthly salary of rupees 12,000. Question number 48. Which of the following is incorrect statement with respect to Lok Adalat? Incorrect statement. No court fee is required in Lok Adalat. It is correct option. Lok Adalat can deal with all civil and criminal matters. Here all civil and criminal matters, it is dicey. Award of Lok Adalat is deemed decree. It is correct. No appeal against the award of Lok Adalat is allowed. It is also correct. So here the statement which is incorrect regarding the Lok Adalat is option number B. Lok Adalat can deal with all civil and criminal matters. No. Lok Adalat can deal only with it can only handle compoundable civil matters. It cannot decide non-compoundable criminal matters. So option B is correct here. Next question. Question number 49. Central Consumer Protection Council as provided under section 3 subclause 2 of the Consumer Protection Act shall consist of a chairperson and 10 other members, or a chairperson and such other members as may be prescribed. No. A chairperson and 5 other members. No. A chairperson and such other members as may be prescribed. Right. So answer C is correct. Option C is correct. A chairperson and such other members as may be prescribed. Next question. Question number 15. Which of the following is incorrect with respect to arbitration agreement as per the Arbitration and Conciliation Act? Arbitration agreement may be in writing, as well as oral. It may be in the form of a separate agreement. Here we are finding for incorrect option. So arbitration agreement may be in the form of a separate agreement. Arbitration agreement may be in the form of an arbitration clause in a contract. Arbitration agreement may be for all or certain dispute which may arise between the parties. Here we have already read that Section 7 of Arbitration and Conciliation Act requires that the agreement must be in writing. Must be in writing. So here option A is incorrect. So arbitration agreement may be written as well as oral. So it is incorrect. Question number 51. In which of the following circumstances an arbitrator may not be challenged as per the Arbitration and Conciliation Act 1996 may not be challenged? Option A is when a justifiable doubt as to his independence arises, it is a ground for challenging. When a justifiable doubt as to his impartiality arises, it is also a ground for challenge. When he possesses the qualification agreed by the parties, no, it is not a ground for challenge. When he becomes ineligible as per the 7th schedule of the act, it is also a ground for challenge. So here the correct answer is option number C, when he possesses the qualifications agreed by the parties. Question number 52. In which of the following situation a one-person company will be mandatorily get converted into either private or public company? In case in case the paid up share capital of an OPC exceeds 25 lakh rupees. No. In case the paid up share capital of an OPC exceeds 50 lakh rupees. Yes. In case the paid up share capital of an OPC exceeds 70 lakh 75 lakh rupees, no. OPC exceeds 1 crore rupees, no. So here the correct answer is in case the paid up share capital of an OPC exceeds 50 lakh rupees or turnover exceeds 2 crores and it sometimes get automatically converted, sorry, after 2021 amendment, these thresholds were removed and allowed for voluntary conversion. Question number 53. What is the minimum number of directors required for a public company as per the Companies Act 2013? This is a repeated question. We did it earlier also. So here, what is the minimum number of directors in a public company is 3. In a private company, it is 2. And maximum number of director is 15. Under section 149 of Companies Act. Next question, question number 54. Under the Indian Contract Act, what happens if the principal debtor leaves part of the debt and unpaid and there are 2 or more co-securities? So the creditor alone bears the unpaid portion of the debt. The creditor alone's highly improbable, so no. The debtor family becomes liable for the unpaid amount. No. The co-sureties share the unpaid portion of the unpaid portion in the equal contribution. Right? Entire unpaid portion is to be paid by sureties first approached. No. So here answer is C. It is given under section 146 to 147 of Indian Contract Act. Principle of equal contribution. Equal contribution. Next question. Question number 55. Which of the following would be the first previous years in case of a business or profession newly set up on 31st March 2020 as per Income Tax Act 1961? Very simple question. Option number A is start from 1st April 2019 and will end on 31st March 2020. No. Start from 31st March 2020 and will end on 31st March 2020. Right. Start from 1st April. Wrong? Wrong. So, option number B is correct here. Start from 31st March 2020 and will end on 31st March 2020. Under the question number 56, under the Specific Relief Act 1963, when may a defendant in possession of a movable property can be compelled to deliver it to the plaintiff? Option number A is when the property is held as agent or trustee of the plaintiff. Option number B is when the property is held as mortgaged asset of the plaintiff. Highly improbable, no. When the property is held as lessee or subtenant of the plaintiff, no. When the property is held as co-owner in common with the plaintiff, no. So here answer is A. When the property is held as agent or trustee of the plaintiff, it is given under section 7 to 8 of Specific Relief Act. Next question. Question number 57. When may two persons are said to be related to each other by half blood in accordance with Hindu Marriage Act 1955? Half blood. When they are descended from a common ancestor by the same wife. So same wife means full blood. When they are descended from a common ancestor by different wives. When they are descended from a common ancestor by different husbands, it is called uterine blood. And when they are not descended from a common ancestor at all, so they are not related at all. Here, the answer is when they are descended from a common ancestor by different wives, then they are said to be related to each other by half blood. Next question, question number 56, 58. Which of the following is generally not considered as a valid condition for a Hindu marriage as per the Hindu Marriage Act of 1955? So, section 5 deals with condition of marriage. Now, the options are: the parties should not have a spouse living at the time of marriage. We are finding the conditions which are not considered as valid conditions. So, the parties should not have a spouse living at the time of marriage. This is a valid condition. The parties should be within the degree of prohibited relationship. No. The parties should not be subindas to each other. This is also a valid condition. The parties should not be suffering from epilepsy. It is also a valid condition. So, parties must not be within the degree of should parties should be within the degree of prohibited relationship. Your answer would be B. Question number 59. Under section 13(1) of Hindu Marriage Act provides for the following. 13(1) ground for restitution of conjugal rights, grounds for judicial separation, grounds for divorce. Only three. Only three. Grounds for restitution of conjugal rights is given under section 9 and judicial separation are given under section 10. Grounds for divorce is given under section 13. Option number D is correct. Question 60. Under the Patent Act 1970, which situation prevents a patent application from being published even after the expiry of the prescribed period. So, here, when the applicant has filed a request for early examination, no. When secrecy direction is imposed under section 35, yes. When the patent has already been granted by the controller, no. When the applicant has requested for an extension of time, no. Here, the clear answer is option number B, when the secrecy direction is imposed under section 35. Moving to next question. Question number 61. What is the meaning of batil marriage in Muslim law? Valid marriage, void marriage, voidable marriage, or irregular marriage. So, batil marriage in Muslim law relates to void marriage. It is void marriage. Valid marriage is called Sahih, H-A-S-I-H, and voidable marriage is called Fasid, F-A-S-I-D. So, here the answer is B, void marriage. Next question. Question number 62. What is a contract of marriage which may be dissolved by wife under a power delegated to her called under the Muslim law? So, talaq us surinat, talaq ul biddat, talaq e tafweez, talaq e hasan. So, here answer is talaq e tafweez. Here it is called delegated divorce. Question number 63. Mr. X owns a bag. Question number 63. Mr. X owns a bakery where he employs Y, a 16-year-old adolescent. At first, X gives Y every Sunday off as his weekly holiday. After 2 months, after 2 months, X decides to change the weekly holiday to Wednesday and pastes a notice about this change on the bakery wall. According to the Child and Adolescent Labor Prohibition and Regulation Act 1986, this change is option A is valid since employers can change the holidays anytime by giving notice. No. Invalid since weekly holidays cannot be altered before the completion of at least 3 months. Valid since the adolescent is given a full day of rest every day. No. Invalid only if the notice is not displayed in the establishment. No. Here the correct answer is B. This change of weekly holiday is invalid since weekly holidays cannot be altered before completion of at least 3 months. And yes, next question 64. A Hindu boy and a Hindu girl may be married under the following law: Hindu Marriage Act 1955, yes, Special Marriage Act 1954. Both 1 and 2 are correct. Through which of the following amendment act the rights in the co-partnership property is made available to a girl child as well? It is Hindu Succession Amendment Act of 2005. It gave co-partnership rights to girls since birth. Right. So option C is correct here. Question number 66. What should what should be the age difference? What should be the age difference between adopted father and adopted daughter for a valid adoption? 15 years, 18 years, 21 years, no specified age. Section 21 years. Section 11 of Hindu Adoption and Hindu Adoption and Maintenance Act 92 mandates that there should be at least 21 years of age gap between adoptive father and adopted daughter for a valid adoption. Next question. Read the given statement and choose the correct option. Under the Negotiable Instrument Act 1881, a negotiable instrument made, drawn, accepted, or transferred without consideration creates no obligation of payment between the parties to the transaction. And second statement is, according to the same act, if the consideration for which a negotiable instrument was issued fails in part, the holder in immediate relation is entitled to recover only the proportionate amount corresponding to the consideration actually received. In the context of above statements under the Negotiable Instrument Act 1881, which of the following is correct? So, both the statements are correct, both the statements are true, and section 43 and 44 of Negotiable Instrument Act says so. Question number 68. Which of the following is not a negotiable instrument under Negotiable Instrument Act 1881? So, promissory note, it is a negotiable instrument. Bill of exchange, it is also a negotiable instrument, and check, it is also a negotiable instrument. B, hundi is not a negotiable instrument, it is an indigenous instrument. Governing custom, and where the instruments are defined? Instruments are defined under section 13 of Negotiable Instrument Act. So option B is correct here. Question number 69. In the light of Negotiable Instrument Act, at what rate interest will be charged if the rate of interest is not mentioned in the negotiable instruments? So it is 18% per annum. 18% per annum is fixed by section 80 of Negotiable Instrument Act. It fixes the rate as 18% per annum when the rate of interest is not mentioned on the negotiable instrument. Next question. Question number 70. Read the following statement and choose the correct option. Statement 1. Under the Administrative Tribunals Act 1985, a joint administrative tribunal for two or more states exercises the same jurisdiction, power, and authority as an administrative tribunal for those states. And statement 2 is, for the purpose of contempt, a tribunal exercises powers similar to those of a high court, and references to High Court in the Contempt of Courts Act 1971 are construed to include such tribunals. In context of above statements, under the Administrative Tribunals Act 1985, which one of the following is correct? Both the statements are true. 71. Which of the following provision of Constitution of India states that no tax can be levied or collected except by authority of law? So, Article 265 Article 265 of the Constitution says that no tax can be levied or collected except by authority of law, and 246 is about distribution of legislative power. 256 is about obligation of state or union. 260 is about jurisdiction over outside territory by agreement. So option number D is correct here. Article 265. Next question. Which of the following would be the first previous year in the case of a business or profession newly set up on 31st March 2020 as per the Income Tax Act? This is a repeated question. Its answer is start from 31st March 2020 and will end on 31st March 2020. Option B is right here. Question number 73. In the following question, a statement is followed by two conclusions, 1 and 2. Statement 1. Under the Environment Protection Act 1986, when an offence is committed by a company, every person who was directly in charge of and responsible to the company at the time of the offence, as well as company itself, is deemed guilty. However, a person may escape liability if he proves that the offence was committed without his knowledge or that he exercised due diligence to prevent it. So, statement is right. Now we see conclusion. A company as well as its responsible officers may be held liable for environmental offences under the Act. Right? An offence or an officer of a company can never escape liability once the company is found guilty of an offence in the context of above statement and conclusion under Environment Protection Act. Which one of the following is correct? Only conclusion 1 follows. Conclusion 2 is not correct because an officer of a company can escape liability once the company is found guilty of an offence, and when he proves that the offence was committed without his knowledge or that he exercised due diligence to prevent it. So option number A is correct. Question 74. As per the Income Tax Act 1961, a person is said to be resident of India in any previous year if he had been in India for a period of following number of days in the previous year. So it is 182 days. It is given under section 6 of Income Tax Act. It is basic condition. So option B is correct here. Next question. Question number 75. Income is defined under which of the following provision of Income Tax Act? So, income is defined under section 2 subclause 24 of Income Tax Act. Section 2 subclause 31 defines person. Section 2 subclause 9 define assessment year. And section 3 defines previous year. Option B is correct. Next question. What is the default interest payable under section 63A of Transfer of Property Act 1882? 6% per annum? No. 8% per annum? No. 9% per annum? Yes. Option C is correct. Section 63A prescribes 9% per annum interest as default rate. Now, question number 77. A company registered under the Companies Act 2013 is required to file a declaration of commencement of business before starting operations. The directors ignore this obligation and the firm commences business activities without filing the declaration. How much penalty can be imposed on the company by the registrar concerned for such compliance? So here the penalty would be rupees 50,000 under section 10A of Companies Act. So right answer is option B. Question number 78. Which of the following is the time limit given under section 17 of property transfer of property 18 Transfer of Property Act 1882? So life of the transferee and a period of 18 years from the date of transfer. So यहाँ option C is correct, either A or B, whichever is longer. This is the keyword here. So section 17 of Transfer of Property Act says that it allows for longer of life of transferee or a period of 18 years from the date of transfer. So it is given under section 17 of Transfer of Property Act. Question number 79. Which of the following is not a fraud as per Indian Contract Act 1872? So fraud is defined under section 17 of Indian Contract Act. Now the options are: a promise made without intention of performing it. It is a fraud. We are finding which of the following option is not a fraud. So a promise made without intention of performing it, it is a fraud. An active concealment of fact by one having knowledge of the fact. So it is also a fraud. Mere silence, if not duty bound to speak, this is not a fraud. And an act or omission law specifically declares to be fraudulent, it is also a fraud. So here the correct answer would be option C, mere silence if not duty bound to speak. Now moving to next question, question number 80. What penalty is prescribed for persons illegally practicing in courts under the Advocates Act 1961? So imprisonment up to 3 months, imprisonment up to 6 months, imprisonment up to 9 months, and imprisonment up to 12 months. So here the answer is imprisonment up to 6 months, and it is given under section 45 of Advocates Act. So the right answer is B, imprisonment up to 6 months. Next question is question number 81. Which provision of the Advocates Act empowers the Bar Council of India to prescribe standards of professional conduct and etiquette to be observed by the advocates? So here the answer is section 49. It empowers BCI 49(1) subclause C. It empowers BCI to frame rules on professional conduct and etiquettes. Section 42 is power of disciplinary committee. Disciplinary committee. Section 42A is powers of committees. 48A is review. So the correct answer is D, section 49. Next question. Which person will not be treated as a consumer under the definition of Consumer Protection Act 2019? So definition of consumer is given under section 2 subclause 1 subclause um, sorry, which person will not be treated as consumer under the definition of Consumer Protection Act 2019. A person who purchases a refrigerator on installment for home use, right? A person who buys a television partly paid and partly promised as for family use, right? A person who purchases goods for the purpose of resale or for any commercial purpose, no, he will not be considered as consumer. A person who uses furniture bought by a relative with the letter's consent, he is also consumer. So here option C is correct. A person who purchases good for the purpose of resale or for any commercial purpose will not be considered as a consumer. Which of the following is incorrect according to Bar Council of India rules? A person can plead in any matter in which he is himself pecuniarily interested. Option B is an advocate shall appear in court at all times only in the prescribed dress. An advocate shall not stand as surety for his client. An advocate shall not influence the decision of a court by any improper means. So option number A is correct, as it is incorrect statement which is asked which of the following is incorrect according to Bar Council of India rules. So, an advocate can plead in any manner in which he is himself pecuniarily interested. Question number 84. According to Section 25A of Arbitration and Conciliation Act 1996, if the claimant, what happens if the claimant fails to submit statement of claim without sufficient cause? So, first option is the tribunal adjourns the case indefinitely. B is the tribunal imposes a penalty but continues proceedings. Third is tribunal assumes the claim is admitted, and fourth is the tribunal terminates the proceeding. So here the right answer is the tribunal terminates the proceeding. It is given under section 25A of Arbitration and Conciliation Act. Next question. Question number 85. Whoever dishonestly or fraudulently makes use of an of electronic signature of any person is punishable for which one of the following offences under the Information Technology Act? Option A. Punishment for dishonestly receiving stolen computer resource or communication device. Option B. Punishment for identity theft, punishment for violation of privacy, and punishment for cyber terrorism. So it is option B which is correct here, punishment for identity theft. It is given under section 66 of IT Act. Cyber terrorism is 66F, violation of privacy is 66E, and A is 66B, punishment for dishonestly receiving stolen computer resource or communication device. Next question is 86. Under the Information Technology Act, okay, कौन सा? Okay. Question number 86. Under the Information Technology Act 2000, Under the Information Technology Act 2000, a person who on behalf of another person receives, stores or transmits a record is considered to be an intermediary. Intermediary is defined under section 2 subclause 1 W of income tax, IT Act. IT Act, Information Technology Act 2000. Now moving towards next question. 87. Which one of the following is not a ground for revoking a digital signature certificate by the certifying authority under Information Technology Act 2000, where a material fact in the DSC is false or has been concealed? So it is a valid ground. Upon death of the subscriber, it is also a valid ground. The subscriber holds a private key and corresponds to the public key listed in DSC. It is not a valid ground. Not valid. The certifying authority's private key was compromised. It is also a valid ground. So these grounds are given under section 38 of IT Act. And here the correct answer is option number C. The subscriber holds a private key corresponding to the public key listed in the DSC. Next question. Question number 88. Appellate tribunal under the IT Act in respect. Consider the following statement in respect to appellate tribunal under the Information Technology Act 2000. The provision of the Limitation Act 1963 shall, as far as possible, apply to appeals made to the appellate tribunal. And an appellate tribunal established under the Telecom Regulatory Authority of India Act 1997 is to be appellate tribunal for the Act. Yes, the appellate tribunal shall not be bound by the procedure laid down by the Code of Civil Procedure. Yes. So here the correct option is option number A, 1, 2 and 3. All the options are correct. Question number 89. Next. Critical information infrastructure means a computer resource, the incapacitation or destruction of which shall not have debilitating impact on which one of the following. So national security, it is the right option, so it cannot be correct. Public health, it can also not be correct. And traffic data is the right answer here. So traffic data, the definition refers to economy national security, economy, public health, safety. It does not include traffic data, so option C is correct here. Question number 90. Which one of the following is not reason? Which one of the following is not the reason for which the central government may authorize to monitor and collect traffic data under Section 69B of the Information Technology Act? So, to enhance cyber security, it is one of the reason for which central government may authorize to monitor and collect traffic data for identification, analysis and prevention of intrusion. It is also one of the reason. Spread of computer contaminant, it is also one of the reasons. Maintain friendly relation with foreign state. No. 90 for question number 90, option D is correct. And maintain friendly relation with foreign state is a ground under section 19 of IT Act. Question number 91. A cyber cafe owner is asked to provide subscribers information to a law enforcement agency. According to the Information Technology Act 2000, what is the owner's legal obligation? So, option number A is extend all facilities and technical assistance to the agency. B is to obtain the user's consent before providing any information under section 67C of the Act, to provide the information based on section 69A of the Act, to provide information based on the orders of controller as per the 68 of, as per section 68 of the Act. So, here the right answer would be A, extend all facilities and technical assistance to the agency. It is given under section 69 of IT Act. So, right answer would be option A. Question number 92. Under section 3 subclause 2 of Information Technology Act 2000, the authentication of electronic records cannot be affected by the use of a systematic or asymmetric crypto system and use of private public key. Asymmetric crypto system and hash function, asymmetric crypto system and hash result, asymmetric crypto system and algorithm mapping. So here the right answer is asymmetric crypto system and use of private public key, and it is defined under section 3 subclause 2 of IT Act. Moving to question 93. A police officer X, while investigating on a matter of house trespass, locates a person who looks exactly same as the person in the video recording that was attached with the complaint, on the basis of which FIR was registered. Which one of the following statement is most appropriate regarding the arrest of the person? Option number A is X may arrest the person without warrant if he has reason to believe. Second option, X may arrest the person but requires an order from the magistrate and a warrant. No. X may arrest a person but needs conclusive proof that the person is same as the one in the video recording. X needs to verify the authenticity of video recording before proceeding with the arrest. So, here the right answer would be X may arrest a person without warrant if he has the reason to believe. And it is given in BNSS section 35. Question number 94. Which of the following parties can file an application for plea bargaining before a court of law under section 290 of the Bharatiya Nagrik Suraksha Sanhita 2023? Option 1. Prosecutor within period of 30 days from the framing of the charge. No. A complainant within a period of 30 days from the framing of charge, yes. The person accused of an offence, within a period of 30 days from the framing of the charge. So here the right answer is 3. 3 only. B. 94 ka B. Only the accused person may apply for plea bargaining within 30 days of framing of charge. Question 95. Which one of the following regarding sentence in cases of conviction of several offences at one trial under the Bharatiya Nagrik Suraksha Sanhita 2023 is not correct? Not correct. So, the punishment of imprisonment may run consecutively or non-currently, or concurrently. So, it is correct option. It is right option. So, it cannot be correct. While deciding whether the punishment shall run consecutively or concurrently, the gravity of the offence must be considered. Yes, in case of consecutive sentences, if the aggregate punishment is in excess of the punishment which the court is competent to award, the offender must be sent to trial court before a high court. No, it is not the right answer, so it must be correct here. because we are finding for an incorrect option. Next question, question number 96. Consider the following statement in respect of service of someone on a firm or other association of individual under Bharatiya Nagrik Suraksha Sanhita 2023. Service can be affected by serving it on any partner of such association, right? It can be affected by a letter sent through registered post addressed to a partner. Which of the statement given above are correct? So here both the statements are correct. So option C is right here. Both option 1 and 2. Right. Question number 97. A sub-inspector who operates in the jurisdiction X has been directed with a warrant to arrest a person who has escaped to jurisdiction Y. The sub-inspector reaches jurisdiction Y but comes to know from the local police that the person to be arrested is already seated in a bus to leave the place. So, which of the following is the most appropriate step? Most appropriate step that the sub-inspector may take under the Bharatiya Nyaya Suraksha Sanhita 2023. First option is he shall take the warrant for endorsement to the executive magistrate of Y. No. He shall take the warrant for endorsement to an officer in charge of the police station in Y. No. He can arrest the person directly. Yes. So here option C is correct because obtaining endorsement may cause delay allowing escape of the accused. So option C is right here. Next question, question number 98. Under section 85 of Bharatiya Nagrik Suraksha Sanhita BNSS 2023, where can an order for attachment of property of an absconding person be issued? First, as soon as the information of absconding person is received in the court. Second, any time before a proclamation requiring the person to appear at a specific place and time has been issued by the court. Third, at any time after the warrant of arrest of the absconding person is issued by the court. And D, at any time after proclamation requiring the person to appear at a specific place and time has been issued by the court. So it is option D, any time after a proclamation requiring the person to appear at a specific place and time has been issued by the court. So, moving to next question. Question number 99. When a person who is bound by any bond or bail bond taken under Bharatiya Nagrik Suraksha Sanhita 2023 to appear before a court does not appear, the court may issue a warrant directing that such person be arrested, may issue a warrant to locate such person, shall issue a warrant directing that such person be arrested, shall issue a warrant to locate such person. Here, the correct answer is A, may issue a warrant directing that person be arrested. Next, question number 100. Last. A police officer X, while investigating a financial fraud matter, finds that one of the suspects had purchased a luxury yacht, which X believes that the same is derived as a result of criminal activity and is about to flee to a foreign country immediately. X immediately, with the approval of the superintendent of police, applies to the court for taking cognizance of the offence under section 107 of BNSS. Which of the following steps the court take? First, the court may issue a notice calling upon such person to show cause within 10 days as to why an order of attachment shall not be made. Second, the court may, by an interim order, pass ex parte direct attachment of the luxury yacht if it feels that a notice would defeat the object of attachment. Third is, The court has to first decide whether the said properties proceed of time. No, the court cannot proceed without a notice, as it is against the principles of natural justice. So here option B is correct. The court may be an interim order, may by an interim order pass ex parte direct attachment of luxury yacht if it feels that a notice would defeat the object of attachment. So that's all for today. Yes, it is under section 107. So that's all for today. Thank you so much.